Morning, everyone. This is Kristen O'Neill with the New York State Committee on Open Government. Today, thank you for attending our Freedom of Information Law information session. It's a program geared towards anyone who wants to learn a little bit more or sort of being reminded of rights and responsibilities under the New York State Freedom of Information Law. This program is being recorded and will be posted on the Committee on Open Government's website, hopefully by the beginning of next week. Usually I can get it recorded and up on the website within about a week. In addition, I have requested that the materials the PowerPoint that I'm using today will be available also on our website, so that looking to use the PowerPoint as a resource, that will be available for you all as well. If you have questions, you're welcome to enter them into the chat feature. I will answer questions at the end of the program, just because as a one-woman show, it's a little bit difficult to go back and forth between the PowerPoint and the chat. Also, as a point of reference, I'm not going to be able to provide technical support. Sometimes people send me notes in the chat feature saying they're having difficulty using the program for something's happening. That's not something I'm going to be able to assist with as we're teaching the program. With that all said, we can get going. Before we start with the PowerPoint, I would like to share with everybody, one moment, I'm going to show everybody what our website looks like. So right now you're looking at the website for the New York State Committee on Open Government. It's opengovernment.ny.gov. You'll see on the home page, we try to put sort of new interesting information that's going on, guidance documents that we think would be helpful to people. If I am offering one of my virtual programs, that will be generally on our home page here. As you dig a little bit deeper into our website, if you hover over the menu items, the Freedom of Information Law, we have copies of the law, we have the regulations, our advisory opinions, case law summaries. The same is true for the open meetings law. We have information about the meetings of the Committee on Open Government. So you will find, first, of course, we will put a notice of any meeting of the committee, primarily posted on our website. In addition, you'll find it here. Our meeting minutes will be posted here, and About Us page that tells you information about our executive director and our committee members, and we have a Contact Us page that has our phone number and our email address. As you scroll down a little bit, there's also some additional helpful information. There's sample language for making a FOIL request, for appealing FOIL requests. There's an overview on the time limits that apply to FOIL. There is, if you are a municipal entity or some sort of good government group or a media organization and you would like to request training from our office, we have contact information for you there. If you'd like to view a meeting of, if you missed a meeting of the Committee on Open Government and you would like to view the recording, that's available here. And the programs that such as the one I'm doing today, these are generally recorded and posted here. If you go to this page, you will see, I don't believe it's been updated yet, but I did put in a request this morning for the PowerPoints that I'm using today for both my FOIL program and my Open Meetings Law program, the most up-to-date version. I did put a request in today for that information to be posted on this page. So you'll see there's a link for viewing the recordings. There's a link for viewing the training materials for both FOIL and the Open Meetings Law. All right, so I'm going to skip back over. I'm going to stop here, and now I want to go back to sharing my PowerPoint. There we go. All right, up on the screen, as I mentioned at the beginning, my name's Kristen O'Neill. I'm the Assistant Director of the New York State Committee on Open Government. Up on the screen right now is the office's telephone number. We have a total of 4 attorneys in our office, including our Executive Director, myself, a senior attorney, and our Excelsior Fellow. So we are all attorneys that can answer your questions regarding the Freedom of Information Law and the Open Meetings Law. You can contact us by phone. You can contact us by email. Our email address I do have again at the end of the PowerPoint, but the address is our acronym, which is COOG, C-O-O-G, Committee on Open Government, COOG at DOS, as in Department of State, .ny.gov. So anytime you have questions, you're of course welcome to contact any one of us individually, but if you're just trying to get an answer as quickly as possible, the COOG address or COOG email address is a great one to use. New York State Freedom of Information Law is codified in Public Officers Law, Article 6, Sections 84 through 90. As I mentioned earlier, we always keep an up-to-date version of the Freedom of Information Law on the Committee on Open Government's website. As soon as we become aware of any amendments to the statute, we put that up, we amend the language that's on our website. So hopefully it is, in general, up to date. In terms of what's available, in terms of the statutory language. If you ever become aware, if you ever, for some reason, are poking through and notice that something doesn't seem right, you can always ask us and we can double check for you. Here's a picture of our homepage, but I showed you that in person, so we've gone over that. So backing up to the history of the Freedom of Information Law very briefly, the original law was enacted in 1974. It was pretty limited in scope. The law gave the public the right to have access to 9 categories of records. And if the records that you were seeking were not included in those 9 categories of records, you didn't have a right to access them under the Freedom of Information Law. That version wasn't particularly popular, and it was repealed and replaced in 1978 with what is essentially the current version of the statute. Of course, with amendments over the years, but with the basic premise that the Freedom of Information Law is based on a presumption of access. So what do we mean by that? Is that whenever an agency receives a Freedom of Information Law request for a government record, they should start with the assumption that all records possessed by their agency are subject to FOIL disclosure. Then they can review the record to determine whether it or any portion of it fits into one of the permissible grounds for denial. Who is covered by FOIL? FOIL governs access to agency records. That's the term used by the statute, agency. The term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any one or more municipalities thereof, except the judiciary or the state legislature. And as I'm talking here, you all might know, as if you were scheduled to be with me last week, again, I apologize for the last minute cancellation, but you'll notice my voice is still a little bit funky. So if you hear me pause at any point, it's probably because I need to take a drink of water because my voice is still a little bit scratchy from last week. But anyway, so government agencies such as any state agency under the executive, for Department of State, Department of Labor, Department of Health, etc., State Education Department, Office of the Attorney General, Office of the State Comptroller, all of those state level entities are agencies subject to FOIL. Then you work your way down to the more regional levels of government, county, city, towns, villages. All of those entities are agencies subject to FOIL. School districts, public libraries are subject to FOIL. Fire districts. There are thousands of units of local government across the state of New York, and all of those units of local government are subject to the requirements of the Freedom of Information Law. So you'll note here I say except the judiciary or the state legislature. So the courts are exempt from the Freedom of Information Law. You cannot make a Freedom of Information Law request for records maintained by the courts. So for example, Albany County Supreme Court, Albany City Court. I live in Bethlehem, town of Bethlehem, Bethlehem Town Court, for example. None of those entities are required to respond to Freedom of Information Law requests. It doesn't mean that court records aren't to a large extent public records. It's just that the Freedom of Information Law is not the appropriate statute to rely on in obtaining those records. In the state legislature, there are sections of the Freedom of Information Law that govern access to state legislative records. It's just that they are not subject to FOIL in the same broad way that all other government entities are. Access to state legislative records is very similar to the original 1974 version of the statute, where FOIL provides a list. This is what you can obtain from the state legislature, and if you don't see it on this list, you don't have a right to access it under the Freedom of Information Law. Every agency that is subject to FOIL is required to designate one or more records access officers. What the law states is that the governing body of a public corporation, the head of an executive agency, governing bodies of all other agencies shall be responsible for ensuring compliance with the regulation herein. So that's important to note, is that the entire agency, specifically the head or governing body of the agency, is ultimately responsible for complying with the Freedom of Information Law. The records access officer is simply the individual designated by name or by specific job title who has the duty of coordinating the agency's response to public requests for access to records. So every agency's FOIL policy should include either, again, by name or by job title, the individual who's been designated to serve as records access officer. The policy should include a business address and an email address. Term records talk about how the Freedom of Information Law governs access to government agency records. The term records is defined very broadly under the Freedom of Information Law. It means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. And then it gives a list of examples. But as you know, it's very, very broad. Any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form. That means as soon as you send an email as a government employee, if you send an email to one of your coworkers, that becomes a record subject to rights of access under FOIL. Any notes that a government entity takes, any database that a government agency maintains, any video, any audio, any data reports, any internal memos and communications, they are all records subject to rights of access under the Freedom of Information Law. And when I say that, I don't necessarily mean that all of those records are going to be required to be disclosed, just that they are records that the agency needs to review, start with that presumption of access, and review to determine whether there are any grounds for denial of access. An agency subject to FOIL is not required to create records in order to respond to a Freedom of Information Law request. This does not mean an agency is not required to make copies of records or to convert them to a preferred format if possible, just that an agency is not required to answer questions. For example, if someone writes to an agency and says, please explain to me why you made this decision, that's a question. An agency is not obligated to answer questions. An agency is not required to create new records that never existed before, in order to respond to a FOIL request. So sometimes, for example, if someone asks for a list of certain things, the agency may not have that list. They may have records that contain information that the individual is seeking, but maybe they don't have a list that contains the information that the person's seeking. So when making a Freedom of Information Law request, you want to keep that in mind, that an agency is not going to require to answer questions or to provide information that does not already exist in record form. There are 3 exceptions to the rule that an agency is not required to create a record. One is every agency that houses a public body, subject to the Open Meetings Law, is required to maintain a record of how each member of the public body voted on every action taken. So under the Open Meetings Law, minutes are required to be prepared, and those minutes are supposed to include a record or summary of all actions taken, or for example, any motions, proposals, resolutions, or any other action taken that required a vote, and the results of the vote. But it doesn't specifically say that the minutes need to include a record of how each member voted. However, Freedom of Information Law does require that. The Freedom of Information Law requires that there be a record of how each member of a public body voted on any given action. Another exception to the rule is that every agency is required to maintain and make available a list of the name, public office address, so not home addresses, public office address, name, public office address, title, and salary of all of its public employees and officials. The third exception is every agency is required to maintain a reasonably detailed subject matter list of the records that it maintains, regardless of whether or not those records would be available under the Freedom of Information Law. Many local units of government adopt the New York State Archives Record Retention and Disposition Schedule, which is shorthand is the LGS-1 put out by the New York State Archives as their subject matter list, and this is perfectly acceptable. It lines up nicely with what is expected to be included on a subject matter list. So many, as I said, many local government agencies simply adopt the LGS-1 as their subject matter list. So as I've been mentioning, there's no obligation for an agency to create a new record in response to a Freedom of Information Law, but we want to be careful about making a distinction between creating new records and preparing copies of existing records. The law states that an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have such copy made by engaging in outside professional service. An example here may be if an applicant for records is asking an agency to scan a record and attach a copy of the electronic scanned version of the record to an email and provide it to them in that format. If the agency has the ability to do that, if they have a multifunction copier that includes the ability to scan a record, then they should scan the record if they have the ability to do that and provide it to the applicant in that electronic format. Another example here is sometimes people very specifically are requesting that records be provided to them in their original format or in an editable format, for example. Let's say that the agency maintains an Excel file that contains certain data, and the applicant is seeking a copy of that Excel file. We sometimes get questions from the agency saying, do I really need to provide it to them in the Excel format? Can I print it out and scan it or convert it to a PDF first so that they can't edit it? And the answer is no. If the person wants the record in the original or specific format, and the agency has the ability to provide it in that format, it must. When an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. And any programming necessary to retrieve the record and to transfer that record to the medium requested by a person, or to allow the transferred record to be read or printed, shall not be deemed to be the preparation or creation of a new record. This is statutory language. So what this legislature intended here was that oftentimes, as post 1978, the world, of course, became more and more electronic, and agencies were maintaining data in electronic databases, computer storage systems. And there was oftentimes, excuse me, my voice is going a little bit, sorry about that. Sometimes an individual, an applicant for records, would request a record that contains certain data elements. And this might not be a report or a record that the government agency prepared in the normal course of business, so perhaps they didn't already have it in Excel or Access or Word or PDF. They actually needed to go in and query the database and produce the record that's being requested. That is not, under the statute, considered the preparation or creation of a new record. The law considers the data maintained in the database to be the record, and the extraction of the data and putting it in a format that's available to the public is merely making a copy of existing data. So essentially what the law is saying is you can't refuse to query your database simply by taking the position, well, this isn't a report that we prepare in the normal course of business, so we don't have to do it. The law is saying specifically, no, you do have to do it as a government agency. If you have the ability to query that database and produce the record that is being requested, a government agency must do so. When an applicant makes a request for records, the applicant has an obligation to reasonably describe the record sought. So what does this mean? Well, first, they should be using, perhaps, they don't need to name the specific, like, for example, the name of the report, or the sometimes we have forms or names for the reports that internally within a government agency, we know what it's called. We know what the name of the document is called, but the public might not know. But the public may know that the government agency maintains the information. They just don't know the name of the report or the name of the document. So as long as the applicant reasonably describes the type of record that they're seeking, that's what they're required to do. If you as a government employee receive a request for records and you review the request and you just simply don't know what the person is asking for, the best thing to do is, of course, follow up with the applicant and have a conversation with them and see if you can try to work out what exactly is this person seeking. The second aspect of the obligation of the applicant to reasonably describe the record sought is actually based on, I think we're going on 40-year-old Court of Appeals case law that talks about the ability of an agency to locate or retrieve records with reasonable effort. And of course, the answer to this will likely be different depending on whether the records are maintained just as paper records or whether there are electronic copies or an electronic searchable database of those records. The Court of Appeals case law had to do with, it was an inmate that was searching for all records relating to himself, I believe. Everything maintained by the Department of Corrections relating to himself. And even though the request was voluminous, the court held that the Department of Corrections did have the ability to locate all records relating to a particular inmate with reasonable effort. However, they very specifically noted that there will be situations where an agency may not be able to do so, and that if locating the specific record sought even if the agency is confident that they do possess the record, but that locating that record would be similar to locating a needle in a haystack, the court held that the agency would not be required to engage in that sort of Herculean effort of locating the records. An example I give here is if you look up at the screen, you'll see a picture of a filing cabinet. This is an old picture of a filing cabinet that actually exists in my office at the Committee on Open Government. And what it does is it contains copies of appeal determinations that the Committee on Open Government receives. Whenever an individual files an administrative appeal and the agency responds to that appeal, the agency is obligated to provide the Committee on Open Government with a copy of the appeal and a copy of their appeal determination. Every day when the Committee on Open Government receives these appeals and appeal determinations, whether it's by email or by mail, we review them and then they essentially get filed. If there's something that it raises a red flag, certainly we'll address that, but generally we review them and they get filed. Maybe let's say 10 years ago, what would happen is most of the appeals that we were receiving in the mail. And we would get the paper copies and they would get placed in a filing cabinet based on the date they were received. If someone came to the Committee on Open Government 10 years ago and said, please provide us copies of all appeal determinations issued by the Department of State, we would have had a very difficult time complying with that request because we don't maintain our records. I shouldn't say don't. We didn't 10 years ago maintain our records in a manner that would have allowed us to locate appeal determinations issued by any particular agency with reasonable effort because we just filed them by date received. However, in the past several years, we've started logging those logging those appeals, and we keep a database. We keep a fairly simple Excel file of the name of the person who filed the appeal, the name of the agency that issued the appeal determination. And so if someone came to us again today and asked for copies of appeal determinations issued by the Department of State, we would be able to comply with that request with reasonable effort because we now maintain an electronic database of those appeals. Excuse me. Time limits. Under the Freedom of Information Law, there are certain time limits that apply to the manner in which an agency is required to respond to a Freedom of Information Law request. The first time limit that comes into play is 5 business days. An agency is required to do something with all Freedom of Information Law requests within the first 5 business days. They can either provide access to the record sought if it's a simple request. They can deny access to the record being sought if within that first 5 business days they locate the record and determine that it can be withheld in whole or in part. They can take that step. They can search the records and determine that they do not possess the record sought. So that's a third option that can occur within that first 5 business days. The fourth option comes into play when an agency needs more than 5 business days to respond to a Freedom of Information Law request. And what the agency is required to do at that point is to acknowledge receipt of the request, provide a approximate date by which they plan to respond. If the agency requires more than 20 business days from the date of acknowledgement, so 20 business days is going to be your rule of thumb. Anything up to 20 business days from the date of acknowledgement is generally going to be determined to be a reasonable time frame for responding to a FOIL request. However, if an agency requires more than 20 business days to respond to a FOIL request, The agency is obligated to provide a date certain, so sort of a drop dead date, a date certain by which it plans to respond that is reasonable under the circumstances. The agency is also required at that point, if they need more than 20 business days, to explain to the applicant why they need more than 20 business days. So they're supposed to provide the date and the reason for the delay. The Committee on Open Government has long opined that agencies should not be engaging in repeated extensions. They essentially get a couple bites at the apple, the 5 business days, the 20 business days, then the date certain. From our perspective, that's it. That's all an agency is permitted to do. I will acknowledge that the courts haven't necessarily agreed with the Committee on Open Government on this issue, based on some sort of gray interpretation of the statute. The courts basically are going to be looking at the reasonableness of the delay. But for everybody's benefit, I'll give you my perspective on why engaging in repeated extensions is not helpful to anyone, including the agencies. Certainly from the applicant's standpoint, an applicant is always appreciative when they know exactly how long it's going to take for an agency to respond to the request. That's helpful to the applicant. In addition, if the agency is doing a proper evaluation of the request right off the bat and can determine that maybe, for example, a request that they receive is so voluminous and is going to be so time consuming that they've determined that it's going to take 1 full year to respond to this FOIL request. If they tell the applicant that right off the bat within that first month, for example, there's probably a good chance that the applicant might say, I did not realize it was going to take that long. I didn't realize we were dealing with that type of volume of records. I think what I would like to do is narrow the scope of my request so that I can get the specific records that are of most interest to me in a much shorter time frame. So that's where I say that being evaluating the request up front and providing that clear date certain right off the bat is beneficial to everyone. When an applicant, when an applicant is denied access to a record, the applicant has 30 calendar days to appeal that denial. When an agency receives an appeal, they have 10 business days to respond to the appeal. Agencies must accept requests via email. Agencies cannot require a requester to use its own form, and when I say use its form, I'm also including electronic forms and portals. Many agencies provide access to portals for submitting FOIL requests, and this is wonderful. It's a great benefit. I am not knocking the portals. But my one concern about the portals is that oftentimes these like Gov2A and other things similar to that, they request a lot of information and make fields mandatory for submitting a request through the portal that the applicant for records should not be required by law to provide. Not that the agency can't ask for that information, but that the applicant should be able to submit a request for records without filling out all the required fields that portals often mandate. So that's my concern with portals. If an agency does have a portal for submitting a FOIL request and that portal asks for more than the most basic of information, in my opinion, they should also be making submission via regular email an option. They should have the portal and, in addition, an email option for the applicants. An agency can always require that FOIL requests be made in writing. From the agency perspective, if we're talking about, for example, town or village government, and they walk up to the town clerk's window and make a verbal request for a copy of last week's meeting minutes, and the town clerk would like to just say, sure, here it is, here's a copy, no problem, that's fine. The town clerk is more than, the records access officer can certainly respond to a verbal request if they would like to. But the records access officer, the municipality, the government agency can require that the request be made in writing if they would like to. Uh, Unless there are personal privacy concerns, an applicant for records should be permitted to remain anonymous. If someone, for example, is submitting a FOIL request for a copy of a publicly available government contract, the person making that request should be permitted to remain anonymous because the identity of the applicant is irrelevant. And this is another issue that I sometimes have with these portals, is that so the portals are asking for a name and home address and telephone number, and a lot of those fields are mandatory, and you can't submit the request unless you complete all those forms. So from my perspective, there should be other options available if someone does not wish to provide that information. Appeals. There are two situations under the Freedom of Information Law that give rise to the right to file an administrative appeal. The first is an express or an affirmative denial of access, and these aren't statutory terms, they're just sort of shorthand terms that I'm using. And that's a situation where the agency possesses a record that's responsive to the request, but it is being withheld in whole or in part. That's the case, the agency is supposed to issue something in writing explaining the reason for the denial and advising the individual of their right to file an administrative appeal within 30 calendar days and to whom that appeal should be directed. The second situation that gives rise to the right to file an administrative appeal is when there is a constructive denial of access. And again, I'll say that this is not a statutory term. You won't find the term constructive denial of access in the statute. It's essentially when the agency fails to respond to a FOIL request within the time limit set forth in the statute. Either it's not acknowledged within 5 business days, or it's acknowledged and the agency says they will get back within 20 business days and they fail to do so. Anytime an agency fails to respond to a FOIL request within the time limit set forth in statute, an applicant is permitted to treat that failure as a denial of access and to file an administrative appeal with the head or governing body of the agency. We have model language on the Committee on Open Government's website for both of these types of appeals. There's a lot of information up on this screen and on the next screen. I'll remind everyone at this point that this information, that this PowerPoint is available on our website, so people shouldn't feel like, that they need to take notes or anything. It's all right there on our website. I did ask for the most up-to-date version of these slides to be posted, so hopefully within the next 24 hours, this exact PowerPoint will be posted on opengovernment.ny.gov under our training materials section. So we're going to talk about some of the permissible grounds for denial. To a large extent, with one exception, all of these grounds for denial that an agency is permitted to assert are just that, they're permissive. An agency is permitted to withhold certain records under the Freedom of Information Law, but is not required to. We're going to talk about the exception first. The exception to that rule is when a particular type of record is exempt from FOIL disclosure by New York State or federal statute. If there's a type of record where another state or federal statute governs access to that record, then that's the statute that you want to pay attention to. You're essentially going to a large extent, throw FOIL out the window, and the agency is going to want to comply with that statute. And if that statute states that the record cannot be disclosed, certainly the agency needs to comply with that separate statute. So here are some examples. There is, let's start with for school districts. If someone makes a FOIL request for the kid down the street's education records, those records are confidential under under federal statute, the Family Educational Rights and Privacy Act. student records at both, elementary school, high school, community college, SUNY, CUNY, any public institution of learning, those records, any educational records are confidential under FERPA, but when you're dealing with public entities such as school districts or community colleges, SUNY or CUNY, someone might ask, well, should I be complying with the Freedom of Information Law here, or should be complying with FERPA? FERPA is always going to take precedent. That specific governing statute is always going to take precedent over the Freedom of Information Law. Another example here are mental health records. Prior to my time here with the Committee on Open Government, I served as Records Access Officer for the New York State Office of Mental Health. And sometimes we would receive Freedom of Information Law requests for mental health records. Sometimes it was for their own mental health records, excuse me, but often it was for the mental health records of another individual. And I always had to just simply advise them that meant that the Freedom of Information Law is not the appropriate mechanism for requesting those records. Even if they're your own records, there are certain provisions under the New York State Mental Hygiene Law for requesting your own mental health psychiatric records. There's a review that must be conducted. So New York State Mental Health Law is always going to take precedent over the Freedom of Information Law. Another example is autopsy records. Access to those records is governed by county law. County operated E911 records, access is governed by county law. Under federal and state statute, social security numbers should never be disclosed. So these are the examples, this first ground for denial where a record is exempt from FOIL disclosure by state or federal statute. This is the one situation where withholding a record is in general going to be mandatory. An agency is going to be prohibited from disclosing those records in many instances. The rest of the grounds for denial that we talk about are going to be permissive under the Freedom of Information Law. Second example here is unwarranted invasion of personal privacy. Examples of an unwarranted invasion of personal privacy are employment applications of individuals that were not hired to fill a job in a public agency. So for example, if the Department of State has a job opening and 10 people apply from the public to fill that position, only one person is hired to fill the public position, the applications or the resumes, the names of the individuals that applied but were not hired can often be withheld, or at least the resumes or applications could be redacted sufficiently to protect those individuals' privacy, their identities. Home telephone numbers and personal cell phone numbers can be withheld on personal privacy grounds, and this is true for both public employees and for any other member of the public. If there's a record that contains an individual's home telephone number or personal cell phone number, generally that information could be withheld as an unwarranted invasion of personal privacy. Medical information, perhaps contained in a public employee's personnel file or for any other reason, certainly if it's a public health provider, access to medical records is going to be governed by New York State public health law and HIPAA privacy regulations. But sometimes government agencies records contain medical information about an individual that is not governed by HIPAA. And the example that I gave, for example, might be like for a workers' comp or a reasonable accommodations request contained in a public employee's personnel file. That type of medical information could be withheld where disclosure would constitute an unwarranted invasion of personal privacy. Public employees' home addresses can be withheld. Lists of names and addresses of natural persons if that information would be used for solicitation or fundraising purposes. Sometimes we see agencies trying to request certifications from the public that no information that they obtain through the Freedom of Information Law will be used for solicitation or fundraising purposes. That is an incredibly overbroad interpretation of what the law allows. The only time an agency can require an applicant certify that they will not use information for solicitation or fundraising purposes is when the records requested include names and either mailing addresses, home addresses, or email addresses of natural persons. And by natural persons, I mean, you and me in our personal capacity, as opposed to businesses and vendors or individuals working in a business capacity. Sometimes I use the example of dog licenses. Everyone who wants to get a dog license from their municipality, the municipality maintains the names of addresses of everyone who's been issued a dog license by their municipality. If someone comes and makes a FOIA request for those names and addresses, the agency can request a certification that the information will not be used for solicitation or fundraising purposes. So if the person making the request owns like a mobile dog grooming operation, they probably are not going to be able to complete that certification honestly and truthfully, and the request can be denied because disclosure would constitute an unwarranted invasion of personal privacy. Mugshots, it's a fairly recent amendment to the statute. In the past 5 or 6 years, the law was amended to include disclosure of mugshots as the type of record where disclosure would constitute an unwarranted invasion of personal privacy. Law enforcement. It's a two-part test. And in order for a record to be withheld, it has to meet both parts of the test. The first is the record must be compiled for law enforcement purposes. And in order to determine whether a record is compiled for law enforcement purposes, you look to what the purpose of the records was at the time of the request, not the original creation of the records. This is based on fairly recent, from 2017 court decision that said that a agency is permitted to look at what the records are being used for at the time of the request. And this had to do with time and attendance records of an individual who worked for the governor's office. Certainly time and attendance records are generally, for public employees, are generally public, and they would not normally be considered law enforcement records. But the time that the New York Times made the request, those time and attendance records had been gathered and compiled by the governor's office to be turned over to the United States Department of Justice. So the governor's office took the position that those records have been compiled for law enforcement purposes, and the court agreed. The exemption also applies to records that have been compiled for a civil law enforcement purpose, such as law enforcement purposes or law enforcement activities conducted by the New York State Department of Education or Department of Labor, Department of State, any entity that has a civil law enforcement function. So that's the first part of the test, where a record has to be compiled for law enforcement purposes. The second part of the test is, would some sort of harm be caused by the disclosure? The first harm described by the statute is when disclosure interfere with a law enforcement investigation or judicial proceeding. If a fairly recent amendment to the statute states that if the entity that receives the FOIL request is not the entity that is conducting the law enforcement investigation, they're required to receive confirmation from the entity that is conducting the law enforcement investigation to determine whether disclosure of the records would interfere with the investigation. So they can't just guess. The person that maintains the records can't just guess. They actually have to get some sort of confirmation from the investigating agency as to whether disclosure would cause harm. The second harm would be whether disclosure would deprive a person of a right to a fair trial or impartial adjudication. Would disclosure identify a confidential source or disclose confidential information relating to a criminal investigation? Or would it reveal non-routine criminal investigative techniques or procedures? And what I mean by that is, would disclosure of certain techniques or procedures to the public allow the public to evade law enforcement detection? Would it sort of give a potential criminal the combination to the safe? Interagency and interagency materials. The purpose of this ground for denial is that it was intended to protect the deliberative process of government agencies. So communications that are shared entirely internally within a single agency, emails, memos, draft documents that are, that haven't been finalized and that are still under consideration. If they stay within a single agency or are shared only between two or more government agencies, they can be considered intra-agency and interagency material and can be withheld. However, if that document or record contains statistical or factual tabulations or data, instructions to staff that affect the public, final agency policy or determinations, or external audits, including audits conducted by the Office of the New York State Comptroller, those portions of the intra-agency or interagency material would need to be disclosed, and the agency would be permitted to redact, for example, any aspect of the record that contains anything other than the 4 items here that are required to be disclosed. There's a provision of FOIL that requires agencies to provide certification upon request under 2 situations. First, I'm going to note that when an agency responds to a FOIL request indicating that it does not possess the records sought, that is not a denial of access that gives rise to the right to an administrative appeal. An agency cannot provide what it does not have. But sometimes an applicant is questions whether a diligent search was conducted, whether the agency actually reviewed the request and responded appropriately, and what the law allows for in that situation is that the applicant can request a certification, a legal written statement from a public employee certifying that the agency does not possess the records sought or that the record cannot be found after a diligent search. If an applicant requests that certification, the agency is required to provide it. We at the committee often get questions about how long an agency has to provide that certification, and it's a good question because the law is silent in that regard. But what I tell people is if the agency did what they were supposed to do right off the bat and conducted the diligent search before responding in the first instance, there really should be no delay at all in providing the certification. The agency certainly should be able to turn that around and provide a certification in a single day. That's just my opinion, however. It's not set forth in statute. Sometimes receiving a request for a certification may trigger something with the agency that prompts them to conduct a second diligent search. And sometimes they're just doing that as a good practice, even though they did the diligence for search in the first instance. So perhaps that might take a little bit longer, but generally it should not take very long for an agency to provide this type of certification. The second situation that where an applicant has the right to request a certification is when they make a FOIL request, they receive a record in response to the FOIL request, and they want confirmation that the copy that they received is an exact copy of the original. They can request a certification as to the correctness of the copy. And that does not mean that they're requesting that the agency is required to certify that the content of the record is all accurate. Like, for example, if there's a report that's provided, the agency doesn't have to certify that all of the information contained in the report is correct and accurate. It simply is required to certify that the copy provided to the applicant looks exactly like the original maintained by the agency. That's what that certification is for. So this is just like sort of the language of the statute. And it's a reminder that this is a shall, an agency shall prepare the certification when it is requested. It is obligated by statute to do so. When an applicant is denied access to a record or any portion of a record, or if there's a constructive denial of access, an applicant has 30 calendar days to appeal the denial. FOIL appeals officer is the head or governing body of an agency or the person or persons designated by the head or governing body. FOIL appeals officer cannot be the same as the records access officer. Within 10 business days, the FOIL appeals officer must either provide the record sought or fully explain the reasons for further denial. Sometimes it's a combination of both those things if we're talking about multiple records. The law does not contemplate a remand back to the records access officer. It is the responsibility of the appeals officer to review the records at the appeals level and to issue a determination based upon their review. And as a reminder, the agency is required to send a copy of the appeal and the appeal determination to the Committee on Open Government. You're welcome to do that by email if it's easier, but you can also still do it by mail if that's your preference. Fee structure. There are two fee structures under FOIL. So an applicant makes a request for records. The only fees that can be asserted are for the fees associated with preparing copies of the records. So the first fee structure is for photocopies. An agency can charge 25 cents per photocopy for pages up to 9 by 14 inches. An agency is not permitted to charge for search or review time. It's not permitted to charge for the time it takes to make the photocopy. The agency can only charge when paper copies are being provided. The only thing that can be charged is 25 cents per photocopy. That's it. End of story, done. The second fee structure is for everything other than for photocopies up to 9 by 14 inches. This could involve records that are larger than 9 by 14 inches, like maps or blueprints, or it could involve records in some other format, like a data extraction, scanning, video, audio, things of that nature. So the law says that in those circumstances, the agency can charge the actual cost of reproduction for all of the records, and then it states this is what you're allowed to consider when determining the actual cost of records. The law states that if you're preparing a copy of something other than photocopies, one element that can be considered is the salary of the lowest paid employee capable of preparing the copies, but only if it takes at least 2 hours to make those copies. So let's use scanning as a simple example here. If the applicant is asking for the records that are being requested to be scanned and emailed to them, and it takes a half hour to scan those records, there will be no cost that can be passed along to the applicant. There's no fee that can be passed along to the applicant because it took less than 2 hours. Once the agency hits that 2-hour mark, though, if it takes 2.5 hours, if it takes 2 hours and 1 minute, if it takes 2 hours on the dot, once you hit that 2-hour mark, the agency is permitted to charge the salary of the lowest paid employee capable of preparing the copies multiplied by the number of hours it takes to prepare the copy. So if it takes, for example, 3 hours to scan all of the records that are being requested, and the hourly salary of the individual in the office of the lowest paid employee in the office that's capable of scanning those records is $15 an hour, then the agency is going to be able to charge the applicant $45. If the records are too large to be sent via email, or if it's just the preference of the applicant, an agency can pass along the cost of an electronic storage device, such as a thumb drive or a CD. If the agency does not have the technological capabilities of making a particular type of copy, for example, audio or video, or maybe something larger like blueprints, maps, in-house, and they need to send it out to a third-party vendor to make the copy, whatever the third-party vendor charges the agency is permitted to charge the applicant. Again, an agency is never, ever, ever, ever allowed to charge for the time it takes to locate the records, to search for the records, and they are not allowed to charge for the time it takes someone to review those records to determine rights of access. Whether it's a clerk or whether it's an attorney, it's not relevant. The time it takes to review those records to determine rights of access is not a cost that is reimbursable under the Freedom of Information Law. In terms of notification of fees to the applicant, when it's the second fee structure, an agency is required by law to notify the applicant up front before incurring the cost of what the cost will be to make sure that they're willing to pay that cost. That's mandatory for number 2. I think is a good practice. It's a good idea even for number 1, particularly if you're making a lot of copies. If you've got a whole file box worth of records and it's going to maybe cost $50, $100 to make copies of all those records, then my recommendation is to let the person know up front how much it's going to cost to make sure that they're willing to pay for it. But it is mandatory when it's that second fee structure. An agency can request payment up front. And we've also offered the opinion that if an applicant agrees to pay a fee and the agency then incurs the cost of making the copies and the applicant refuses to pay, then the agency can refuse to honor future FOIL requests until the applicant pays the fee owed to the agency. A fairly recent, just a couple months ago, the law was amended. Actually, at the end of December, the law was amended relating to fees. It was a fairly minor amendment. It probably isn't going to come up that much, but it was amended again in March. So the amendment was amended in March of this year. And basically what the law now says is when an identical record has been prepared for a previous request within the past 6 months, excuse me, and an electronic copy is available, an agency shall not charge a fee for the reproduction of the record, except for the cost of a storage device, if it's necessary. And this honestly we shouldn't even have needed a statute for this because it's common sense. Under the New York State Record Retention Policy, agencies are required to maintain copies of the records that are provided in response to a FOIA request for 6 months from the time of the agency's final determination. So basically what the law is saying is you should already have an electronic copy. You shouldn't have to incur the cost of making another electronic copy. You should already have one and you should just have to duplicate it. So the law is saying, well, even if you could charge the first person $50 to make the electronic copy of the record, you should already have an electronic copy of that record. And asking the second person, you're not permitted to ask the second person who makes the same request to pay again. It really should have been common sense. But anyway, the law was amended to reflect that. Enforcement. Committee on Open Government does not have enforcement authority. Our role is to provide advice, guidance, legal opinions, training regarding the Freedom of Information Law and the Open Meetings Law. We do not have enforcement authority. We cannot compel an agency or a public body to take any particular action. sometimes we receive requests to issue things such along the lines of counseling memos. I call them slap on the wrist letters. That's not really our role. Uh, if you have questions regarding the application of the Freedom of Information Law and the Open Meetings Law, we are very happy to assist with that. But our role is not enforcement or discipline. We don't investigate complaints. We try to provide the public and government agencies and the media with the tools that they need so they understand their rights and responsibilities under the statute. Enforcement of both the Freedom of Information Law and the Open Meetings Law is through a Civil Practice Law and Rules Article 78 proceeding in state Supreme Court. Attorney's fees and other reasonable litigation costs can be awarded, and it's mandatory on the part of the judge when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. It is discretionary on the part of a judge when a requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time frame. If anyone has questions about the open government statutes, anyone is welcome to contact our office by phone or by email with their questions, whether you're a government employee, member of the public, a media representative, does not matter. All are welcome to contact us. Our phone number is up on the screen. Our general email account is up on the screen. I encourage people to use that email account simply for convenience sake. Like, for example, on Monday, I was driving and on the road for much of the time. So if you had sent me an email, it would have taken me a lot longer to get back to you, as opposed to if you had a simple question that anyone could answer. Whoever was in the office on Monday can respond to your question, even though I was on the road all day. So that's just, I mean, certainly anyone is always welcome if they want to have a question they specifically have for me. I'm happy to always answer those emails. But Coog is the coog@dos.ny.gov is a good account to use for the mere convenience of probably getting the quickest response. So that is the end of my presentation. I'm going to go into the chat feature, and see if we have any questions. I have a nice comment telling me that they're happy that I'm feeling better, so I appreciate that. I don't see any other questions. Let me just see. Oh, hold on, maybe. Yeah, I'm not seeing any other questions in the chat feature right now. If people do have questions that came up during the program that they would like me to answer, again, you're welcome to. You can, for that type of thing where you're following up specifically on my on my presentation, you're welcome to email me, and it's excuse me, my first name, which is KRISTIN .O'Neill ONEILL @dos.ny.gov. A couple questions did come in while I was saying that. Someone asked, are you finding more issues with the CVA and obtaining records from agencies? I apologize, I don't know what you mean by CVA. The person that asked that. Does the appeals officer have to be a paid employee? It has to be, the law states it has to be an individual designated by the head or governing body of the agency. I'm not really sure under what circumstances it would not be a paid employee. But perhaps if you have volunteer town board members and one of your town board members has been designated to be your FOIL appeals officer, as long as I suppose they're a true representative of the agency, that the law is silent in this regard is sort of the short answer. And the first person has said to clarify, it says Child Victims Act and older sexual abuse cases. This has not been a particular issue in my office in terms of providing records from agencies. In general, records that identify victims of sex offenses are confidential under civil rights law anyway, so I don't know that it would particularly have impacted the Freedom of Information Law. There's been for a long time a statute that makes any record that identifies the victim or an alleged victim of a sex offense. Those records are always confidential by by New York State Civil Rights Law, Section 50B. So, but to be honest, that hasn't been an issue. As you may have noticed, I didn't, off the top of my head, know what CPA stood for. So that hasn't been an issue that we've seen with our office. But anyway, as I said, feel free to follow up with me directly if you have a question about the presentation. If just something comes up in the future as you're moving along, you're welcome to contact our office. One more question: if the records need redactions, does that waive the rule that we have to give it in the original format? I think what it comes down to is if you have the ability to redact a record in the form and provide it to the individual in the format that's being requested, you must. If there's no way to redact a record and still provide it in the original format, then I think you have grounds for not providing that original format. I think that's sort of the short answer. So thank you all for joining me today, and I hope you all enjoy. The sun is out, hopefully, at least here in Albany. I hope everyone has a good day, and perhaps I'll see some of you this afternoon if you're really gluttons for punishment. Thanks a lot. Bye-bye.